22 years, predominantly in the courts of Bangalore, so also in various courts across the country, and a senior partner at A&M Global Inc. Today in our midst we have, and we are delighted to have in our midst, Mr. Krishna QC, a Queen's Counsel, a leading criminal barrister, and the author of famous book titled Justice on Trial, Radical Solutions for a System at Breaking Point. Now, just to give a brief introduction about Krishna, he is a practicing barrister exclusively on the criminal side for the last 26 years in the UK, so also in various other countries, predominantly defending on the defense side. Now, before I begin, I would like to request the audience, whoever is watching us on live on YouTube, just to go to the comment section and comment where are they watching us from, which part of the world they are watching us from. We are interested to know that also. And Chris, to begin with, I'll firstly congratulate you on the new book, Justice on Trial, Radical Solutions for the System at Breaking Point. Maybe it's a book that was in the waiting. And I hope that you'll have all the success. The book does well. It guides the whole world in the proper direction in which you, and everybody reads it in the writer's perspective rather than interpreting itself by themselves before completely reading it. So,
well, namaste, Rajendra, to all in India, and thank you so much for having me on your webinar. And as you say, today is the day. The book Justice on Trial was published here in England on the 23rd of July. And so it's been out for 4 weeks now, and it publishes today in India. So you can get it on Amazon in India, and obviously you can order the hard book or the Audible download, or of course the Kindle edition if you want to read it on the train. I know you have some fantastic trains in India and long train journeys. So if somebody wants to have something to read on their long train journey from Mumbai to Delhi or wherever, this is a good read. And I hope they will download it and have a read. And I'm very honored to be with you because India is one of my favorite countries. It's a country I was there just last year. I have enormous respect for the people of India. I've always had a wonderful welcome in India, and I hope to be back soon. And I hope we can have an interesting conversation about some of the things that unite us in our criminal justice systems.
So with your permission, I'll just outline the way in which I would like to take it. Initially, I would like you to enlighten us on the extradition proceedings in the UK court, predominantly because in the recent past, we have seen in our country various high-profile money laundering cases involving tens of thousands of crores, and the alleged perpetrators, once they are booked and found, they escape to UK and take shelter under the UK Extradition Act of 2003. And we have been, even as a citizen, not as a lawyer, even as a common man, we have been watching this on television and the newspapers, seeing that the extradition proceedings are ongoing. This so and so is the development. So, as a nation, we are interested to know how does the courts in UK deal with the extradition matters, particularly when it comes to money laundering. Leave aside the political extradition matters, only the money laundering if you focus. How does it deal?
Of course. So as you know, I've been practicing criminal law for 26 years here in England, and one of my specialties is money laundering and criminal financial crime, fraud cases and white collar crime. So I've dealt with many cases of money laundering, including many cases involving foreign nationals, Indian nationals, Russian nationals, Singapore nationals, and people from all over the world. And as you say, for many years, England, and London in particular, was a place where those who had large amounts of money, which may have been the product of fraud or corruption, would come to London. They would buy property in London, usually using an overseas corporation or a shell corporation, so that they could hide the beneficial ownership. And they would hide their assets here in the UK and live a very luxurious lifestyle in London. I know some of the we have a very large Indian population, as you know, in London, and the great majority of the Indian residents in London are, of course, law-abiding, very respectful and successful people. But there are some who have come here, excuse me, some who have come here who, as you say, have been on the run from Indian justice They jump on their private jet or they get on an aeroplane, they arrive in London. So, and then what happens is the Indian authorities, the Indian government, wishes to extradite them. And over the years, since the 1992 extradition treaty between India and the UK, there have been very few people who have been extradited from the UK back to India. And as you say, the reason for that is the Extradition Act 2003 creates effectively two different kinds of territory for extradition process. There are category 1 territories, which are the EU countries who are signatories to the European arrest warrant system. And extradition to category 1 territories is very easy. It's almost automatic. So there is very little consideration of the evidence in a category 1 request, say from France or from Germany or one of the other EU countries. The process is quick and it's reciprocal. So if an English citizen or a British citizen is arrested in Spain, there used to be a very long process of extradition. Now it can be done in days or weeks, and certainly no more than a few months. So category 1 extradition to Europe or from Europe is very straightforward. But category 2 countries, which is basically all the other countries with whom we have extradition treaties, except the US. And just briefly, it's not strictly relevant to your situation, but for reasons which we don't really understand here in the UK, we have signed a very unusual extradition treaty with the US, which allows the US to request extradition from the UK without producing any evidence. But we in the UK cannot request extradition the other way around. So the extradition treaty we have with the US is hugely weighted in favor of the US and gives them much easier rights of extradition than any other country in the world. And it's caused a lot of big controversy here in the UK. But set aside the UK, India is a category 2 country for the purpose of the Extradition Act 2003. And what that means is that there has to be the courts and the Home Secretary, as part of the process of application for extradition from India, there has to be separate consideration. So first of all, there's a sort of political consideration of the extradition. So we're looking at, is it a political request? Is there an element of manipulation of the process? And that's the sort of political element. But if the government minister signs off and says, yes, this is a suitable case for extradition, then it has to go to the courts. And the government of India has to apply to the UK courts for a warrant of extradition. And where the problems have happened in the past, there's been a number of problems, but where the main problem has been, particularly in cases of money laundering, that the English court will scrutinise the warrant of extradition, the application, and not only the application, but the evidence underlying the application. And the English court will decide whether there is a prima facie case of money laundering or fraud or whatever other crime the extradition is for. And many of these cases, the problem has been that the way in which the Indian authorities have compiled the evidence doesn't necessarily fit with the way that the English courts will judge criminal behaviour for money laundering. And there will be insufficient evidence to connect the money, which is the laundered money on the Indian criminal case, and the crime that was the source of the money. And if the English court is not satisfied that the Indian government can prove a connection between some sort of crime, whether it be drug crime, whether it be usually financial crime like fraud, and that the asset, which is in the hands of the Indian national in London or in the UK, the English court will say, you haven't got a prima facie case. You're missing some of the chain of evidence. And so that is usually the biggest difficulty for the government of India in establishing extradition cases in the English courts, is that the scrutiny of the evidence is such that that it's just not always possible to prove that connection. And even if the Indian government succeeds at the lower court level, what usually happens, because often these Indian nationals, as you know, Rajendra, from your own practice, but the Indian nationals who come to the UK on the run for money laundering or fraud tend to be quite wealthy. They have quite a lot of money. And therefore what they do is they then pay lawyers like me a lot of money to try to stop them being sent back to India. And so what we do is we will appeal from the first decision to the High Court. We may then appeal from the High Court to the Court of Appeal, and we may then appeal from the Court of Appeal to the Supreme Court here in London. And if that happens, the whole process can take years. And of course, it frustrates the Indian authorities because the investigation has gone cold. Often the witnesses may have disappeared, or all sorts of the evidence may not no longer be available in the form of computers or emails or other records. So the strategy of the Indian national who is on the run for crimes of white collar or fraud or money laundering in the UK is to make the whole thing last as long as possible, to try to frustrate the application and eventually just hope that maybe a deal can be done with the Indian authorities or something will make the case go away. But it is a very, very difficult job for the Indian government and the Indian criminal authorities to extradite a wealthy Indian national from London. It's very difficult, it's very hard, and of course there are cases where the UK government has jurisdiction over, for example, corruption. And so sometimes you end up with a situation where a foreign national, whether it's an Indian national or sometimes a national of another country, it has committed acts of corruption in their home country, but the English authorities can prosecute those here in England. So they may choose to do it that way rather than extradite back to the country of origin. So it really all depends. But the overriding message is it's a very difficult thing. And if you have a client who is in the UK and is wanted for extradition, it's really important, obviously, to work with someone like me, an English lawyer, to work alongside the Indian legal team. But there are lots of ways in which the process can be slowed down and in many cases can be stopped altogether. So I hope that's a summary. Happy to answer questions, to expand on any detail, but that's a summary of why it's so difficult to get someone from here in London over to India for a white collar crime like money laundering.
Well said. I have gone through the Extradition Act. Very interestingly, what caught my eyes is this section 13, which deals with extraneous considerations. Extraneous considerations falls within the broad category. That gives a kind of a free way to the person who is sought to be extradited. Now, if the evidence has to be weighed, the fundamental criminal jurisprudence is that any person who is accused of an offense has to undergo the due process of law. Either he may be acquitted or convicted is a different matter altogether, but he needs to undergo the due process of law in any civil society. And we have UN Convention on Corruption, which categorically deals with, or rather UK is a signatory, which says that there shall be cooperation between the states for extradition, which shall be in the very purpose of the extradition proceeding shall be in the nature of seeing that the person whose extradition is sought, unless for political reasons, shall be extradited. Now, how do you analyze this?
You make a very good point. So if you think about it, the reason why the Category 1 territories, why extradition is allowed very easily from the European countries, is because all European countries are signatories to the European Convention of Human Rights. And so there is a presumption that European countries, all of them, will have a fair process of criminal justice which complies with the European Convention of Human Rights. So because that presumption is there, that's why it's almost automatic. Whereas other territories, whilst there is an extradition treaty which allows mutual extradition, there is no presumption. So many cases, you're talking about the extraneous circumstances. In many cases, what happens is that the person says, "I'm going to be attacked by my enemies. I'm not going to have a fair trial. I might be extradited to a court system that's not in Delhi or Mumbai, where perhaps everything is very formal and very official. There are many parts of India which are not so official and don't have such formal processes, and so there's a concern about the standards of justice in some of the more rural parts or the more distant parts of India outside of the cities. So what the defendant does is raise these issues, and one of the duties of the English court when they're applying the Extradition Act 2003 and they're looking at extraneous circumstances is that nobody can be extradited if they're going to face potential physical violence, or if they're going to face a process of law that is unfair and would not comply with the basic standards of the European Convention of Human Rights. So, for example, no one can be extradited if they're going to face the death penalty, because the European Convention of Human Rights prohibits the death penalty. It's not allowed anywhere in Europe. Any country that's signatory to the European Convention cannot have the death penalty. So there are a number of considerations. The death penalty is one. As I say, things like political rivals, political enemies, perhaps even being attacked by rival business people or people who may want to do someone harm. Now, the defendant will raise all of these things, and unless the English court is satisfied that when the person is extradited, they will face a fair trial, they will have a fair judicial process, and that they will be safe from physical harm or attack, they will not allow the extradition to take place unless those safeguards are present. So every single case, the Indian government will face the argument, I'm not going to get a fair trial, I'm not going to be treated, this is a political decision, and that decision has got to be considered very carefully by the English courts. So you're absolutely right that it is unusual, because there is a presumption that there will be extradition, provided the evidence is there. And if it was a European country, that would pretty much be the end of it. In fact, there wouldn't even need to be a consideration of the evidence. But in respect of Category 2 territories like India, the defendant can often find examples of where somebody has been treated unfairly in one of the court systems, or where the prison system is perhaps not fit to keep people safely, and people have been attacked or harmed in the prison system. And these are the sorts of arguments that people use in order to avoid extradition under the exceptional category that you mentioned.
Well, then it's a Herculean task for the Indian authorities, if at all, if they have to extradite. It's better to see that the person is prevented from escaping from the country itself, rather than facing the extradition proceedings in the UK court. So
absolutely.
Thanks a lot.
So the golden rule of law enforcement, and obviously I advise police forces and police officers as well as acting for defendants who are charged with things, but the golden rule is don't let them escape. Because I had a client here a few years ago, strangely, coincidentally, I mentioned this to you on our call yesterday, but he escaped. He was sentenced in the UK, but managed to escape before the sentencing, and he ran away and disappeared for 5 years. And eventually he was arrested in Goa, and the English police were trying to extradite him back to the UK. And as it happened, he died in the police station in somewhat mysterious circumstances. But he never did make it back. But the point is that was 5 years of law enforcement trying to trace him all over the Far East, and eventually tracking him to India. I think he was recognized by chance in the street by an English tourist, and they reported him to the Indian police. But it just tells you, a law enforcement strategy should be to keep the case quiet, because the minute you get leaks, someone is under investigation, that's when they disappear, and then the chances of getting them back are very small. So you're absolutely right, Rajendra. That's what the law enforcement, and I know it happens in this country. I had a client here in England who was wanted on a very large drugs conspiracy. The police went to arrest him after 2 or 3 years of investigation, and he managed to jump out the window and disappear, and he left the country. So the problem is often these big criminals, particularly the very wealthy ones, they have lots of friends in the police, they have lots of friends in the government, they have lots of people that they can, and they get a tip off, and someone says, look, you need to get on a plane, and they do. So the need for confidentiality around these investigations in every country, and not singling out India, but the same applies in the US and the UK, confidentiality is the absolute key to making sure that people don't run away, because when they do, very hard to get them back.
So, but ultimately the public money suffers, public cause suffers, the lapses of few. Of course, I believe in the investigating system. There are wonderful investigating officers in India whose investigation is completely foolproof. Investigation is carried on, like CBI or ED. They are very tough. As you said rightly, despite that, there may be some loopholes by which these people might escape. Anyway, thanks a lot for the extradition, because we'll cover your book also. I'm curious on the contents of your book, which has made my curiosity increase. Before that, because you discussed the USA and UK extradition is little different. Now, of course, one of the extradition matter which the whole world would have followed, even I as a lawyer has followed, is Julian Assange's extradition to USA has sought for. Recently, there were some developments. He was in the Ecuador embassy. Can you just throw light, if you are aware of the recent
Yes,
incident.
well, the Assange case actually was in legal terms was not particularly complicated. The only reason that the Assange case became complicated, of course, was because he was granted asylum by the Ecuadorian government at the embassy in London. That's a very unusual thing. I'm not sure that's ever happened before, because ordinarily not many countries would grant asylum to somebody in their embassy in another country. And so I'm not aware of there being any other examples in England of that happening. So that was what was truly extraordinary, was the fact that he was granted asylum, at least for some time. Of course, eventually the asylum was withdrawn and he was then handed back over to the English authorities. So the situation was this, that Julian Assange had a European arrest warrant out for his arrest from Sweden for rape and other sexual offences, he then decided that he wasn't going to. He was arrested for those warrants and then given bail. He then decided that he wasn't going to go to Sweden. It would have been a very rapid process to take him to Sweden because Sweden's a Category 1 country, and I mentioned earlier how easy it is to extradite to Category 1 countries. So he would have been taken to Sweden many years ago, and he would have had to go through the Swedish criminal justice process. Now, there never was an argument that the Swedish justice system was unfair or that his rights would be infringed, because Sweden is a well-known country with high standards of justice and high standards of human rights and human rights law. What he argued was that if I'm extradited to Sweden, the US may make an extradition request to Sweden to send me to the US for crimes in relation to WikiLeaks. So in other words, what he considered to be political crimes. So he then applied on the basis of political asylum in relation to a potential extradition to the US to the Ecuadorian authorities after he just walked into the Ecuadorian embassy. And then, of course, once he was granted asylum under international law, he was under the jurisdiction of Ecuador. And no one could do anything at all about it. There is no way in which the UK authorities, even though, of course, he was physically and geographically located in London, as everybody, I think, will realise, under international law, a country, the embassy of a country is the sovereign state and the sovereign authority of the country whose embassy it is, just as the Indian High Commission in London is the sovereign territory of the government of India and the state of India. So once he was in effect, in inverted commas, in Ecuador, albeit in the embassy in London, then for all of those years, he was subject only to Ecuadorian law. And there was no right of extradition. There was no process of extradition from Ecuador to the US for this crime, or indeed from Ecuador to Sweden. And he was just, well, there was a process, but he was granted political asylum. So he was able to stay in the embassy. And of course, we all know that he stayed there for many, many years and became somewhat ill by the look of it as a result of being indoors and inside for so long. But in the end, the Ecuadorian government decided they'd had enough of him. He was an embarrassment, so they threw him out, and then he was arrested. Sorry, is that my phone or you? Is that you or me? I've got a FaceTime ringing someone. Let me try. I don't know how to switch it off. No, it's gone. Oh, it's okay. I've stopped it. All right, it's a different machine. It's a different machine. I'm sorry about that. I don't know if you could hear it, but there was a ringing noise. So sorry about that. We found the answer. Anyway, so yeah, he was thrown out, and then as it happened, because he'd been in there so long, the Swedish authorities under Swedish law had run out of time. The crimes in Sweden had been too long ago, and they'd reached their limitation period. The statute of limitations had expired, so he couldn't be extradited to Sweden for that reason, because Swedish law had run out of time. So what happened next was that the US then issued an extradition request to the UK authorities, which of course was what Assange had feared all along. And now that process is taking its long-winded way through the English courts. But he's going to have a big problem because, as I said, for reasons which none of us as lawyers really understand, the US has their extradition treaty hugely stacked in their favor. And it's very difficult for people to stop extradition from the UK to the US because the UK courts under the treaty are not required to consider the evidence in any detail. And so, yes, he's going to argue human rights, he's going to argue political motivation, but if I had to bet on it and make a prediction, I think he's going to lose. And I think he will end up going to the US. But as I say, there was nothing unusual about the case, except for the fact that he spent all those years in the embassy. That was what made it an unusual case, not the law itself. The law was very straightforward. There was a European arrest warrant, and then there's a US arrest warrant. They are going to go through the court process. They couldn't go through the court process when he was a political refugee in Ecuador.
Maybe rather only to dodge the extradition proceedings, he would have got himself a safe haven in the Ecuadorial embassy. That's one of the purposes. We don't know. Maybe
that was the only reason he went in there, was to dodge extradition. He wanted to avoid it, and he couldn't get on a plane because he would have been arrested. He couldn't leave the country because he had no passport, because he had been taken away. So his only means of achieving political asylum, other than perhaps being smuggled out in the bottom of a boat or something, but the only way that he could achieve political asylum was through an embassy in the UK, because he had no way to leave the country. Now, if he could have got on a plane and flown to Ecuador, I'm sure he would have done that. But as it happened, he had no way to do that because he had no travel documents. So, and because he was under bail conditions from the English courts for the Swedish extradition. So he basically decided to use the international law around embassies as his escape route. And he was very successful. He managed to stay there, as you know, for many years.
It's a quite interesting case for all of us as lawyers, as law students to follow.
This is a good case because it very clearly, particularly for lawyers, but also for law students who might be interested, who are coming through, it illustrates some of the really classic principles around the integrity of embassies as the territory of a foreign state, and around the fact that no country can intrude and invade on the sovereign territory of embassies within its nation. And of course, it very clearly sets out some of the interesting features where extradition, human rights, and also the general criminal law become mixed together. Because for me, the one thing that was forgotten in the Assange case for many, many years, and Assange has been very successful at this, was what was forgotten was that several women in Sweden had alleged that he had raped them or committed serious sexual assault against them. Now, that was forgotten. And for a long time, it was all about Julian Assange. It was all about his WikiLeaks and his human rights. And for a long time, it seemed to me, no one was remembering that these women didn't get justice. Whether they were telling the truth, they weren't telling the truth, nobody knows. Because there's never been a trial. Because he avoided having a trial by going into the embassy.
Trial, of course, anybody has to undergo the due process. Thanks a lot for throwing light on that aspect of extradition to India. So also about the Assange's case. Now, curiously enough, I have collected information, or rather some of the chapters from your book, which as firstly as a criminal lawyer interested me, the prison reforms. It sounded, I was perplexed initially. You advocate that the prison has to be done away with. In the prison reforms, you say prison is a university for breeding criminals. Now, can you please explain that?
Yes. So as you know, the book it's not just a book for lawyers. It's a book for anyone. It's about things that should matter to all of us. It's about why we have a criminal justice system. What's it for? What are we trying to achieve? And in order to write the book, I traveled a lot. I was in India last year, in part in research for the book, but I was also in America. I went to the Deep South. I went to Alabama and Georgia in the Deep South of the US. And I went to various countries in Europe, including Switzerland, to look at how they do things. And of course, I have over 25 years experience of going to prisons in England to see clients and going to court and seeing the people coming into prison and then going out and then coming back in again. And so the point of the book was, what's it for? Why do we have a criminal justice system? And in America, as I point out, I give some quite graphic descriptions of how prison is used in America. There are 2.3 million people in prison in the USA on any given day, and it's gone up and up and up. 2.3 million. Now, to put that into context, in the UK, we have 80,000 people in prison, and we have the highest rate of imprisonment in the UK in the whole of Western Europe. So if you think about that, 2.3 million, and we only have 80,000, but that's still very, very high. Our population is about 20% of the US population. So the US have these millions of people, and in the book they call it the city of incarceration. You know, this huge population of Americans, many Black Americans in particular, who are in prison for most of their lives. And the question I was asking throughout the book is, does that mean they have less crime? Do they have fewer murders? Do they have less violence? Do they have fewer rapes or other serious crimes like armed robbery? And of course, you don't need to watch American movies to know that they have one of the highest rates of homicide in the world, particularly gun crime, particularly knife crime. And they have one of the highest rates of deaths from, for example, drug abuse, drug overdose, and drug-related crimes, such as turf wars, where people are shooting each other to get drug territory. So we have many of those same issues in the UK. You have many of those same issues in India. They're not the same, but you have a big drug problem there. You still have criminals who sell drugs. You still have violence that's connected with the drug trade. And you still have a criminal justice system which largely focuses on the drug trade and organized crime. You know, people who commit large-scale crime, including to some extent frauds and so on. But drugs is the number one kind of influence on crime all over the world. A huge, huge issue. So when I came to write the book, all I wanted to do was say, it's all wrong. We're doing everything wrong. And we should be asking ourselves, okay, and one of the chapters in the book is called Why We Should Close All Prisons. Now, of course, people will say, well, there's very lots of violent people and you need to lock them up because they might kill people, they might rape people. That's actually a very small number of people. In the prison population, in our prison population in England, it's only 69% of the prison population are non-violent criminals. They've not hurt anyone, they've not assaulted anyone, they've not harmed anyone. They're in there for a financial crime or a drug crime or something that isn't a crime of violence. And of the 31% who are in prison for some form of violence, most of that is fairly low level, and most of it actually, they would be better served by a community-based sentence or therapy or rehabilitation rather than being locked up in prison. Because the one thing that I found out, and throughout the book, the theme of it is, the more you punish people by locking them away for a long time, the more that you criminalize drugs, the more that you criminalize children. And a lot of the book is about how badly we treat children in England in the criminal justice system. But the more you do those things, the bigger your crime problem becomes, and the more victims you have in your society. You have more people getting robbed, more people being burgled, more people suffering from violence, including sexual violence, if you do things the way that we in England do them now. And I know in India, many of the issues are the same. I know many of your campaigners in India are concerned about prison conditions, are concerned about the way that children are handled by the police and the criminal justice system, and are concerned about the way in which drugs are policed and enforced, and the fact that it gives so much money to organized crime groups and to gangsters. So the themes of the book, and it's published today in India, 20th of August, it's published today. The themes of the book apply just as much to India, and there's some really interesting cases about murder cases I've been involved in, about some of the big drug trafficking conspiracies that I've been involved in, some of the biggest cases that have ever taken place in recent times. I've actually acted for the defense in those cases, all over the television, big media stories. Lots of them are in the book. So I'm using the examples of some of the cases I've done, and I'm saying, okay, this is what I've learned. I've traveled all over the world. I've spent all these years doing this. Here's the answer. Here's what we're doing wrong, and here's what you can do about it. And I really hope people I do want the debate to get started in India, in England, in Australia, where it's going to publish next month. You know, wherever we are in the sort of English-speaking world, or the world, which broadly speaking has a sort of common law system and similar standards and similar ideas about justice that we have in England and India and Australia and all these other countries, Commonwealth countries mainly. You know, let's get talking about how we can do things differently. And if we could get some debate going in the US, because the US publication will probably be next year, that will be great. But I'm not optimistic, because the US are so addicted to the use of prison and so addicted to the war on drugs that I just fear that they're destined to have 5 million people in prison in my lifetime, the way they're going. And I really hope that India and England can avoid going down the same track.
if my study goes correctly, I will ask you. See, I have learned that in the USA, some of the private companies are involved in managing the affairs of the prison.
Absolutely. Well, they are, and they are in England too. I don't know about India, I'm afraid. I don't know what the situation is in India, but in England, many of the prisons are now run by private corporations. As you rightly say, not only are many prisons in the US run for profit by private corporations, and that's something I just cannot agree with or find acceptable, but even the state-run prisons and jails, which are owned and run by the state, they rely very heavily on private corporations for everything from food to building services, to all sorts of other kind of independent contractor services. And there are hundreds of billions a year in revenue to be made from the US prison system. And many of those corporations are making big political donations to American political candidates, whether it's for national office and presidential office, or whether it's at local level, or even, bizarrely to me as an English lawyer, where we don't have elected judges, but where judges are standing for election to be a criminal judge, and they are getting financial support from the corporations that run the prisons. Now that to me must be wrong. There is an incentive on the judge to send as many people to prison as possible to pay money to his supporters, who are corporations running prisons. That it's deeply wrong. It's deeply wrong what's going on in America. Much of it is happening here in the UK, and I really truly hope it isn't happening in India, because it's a recipe for disaster. Once you let corporations in and they make money, the prison system will just get bigger and bigger. Whether that's good for society or not, it will get bigger and bigger because corporations chase the money. It's that simple.
Yeah, but of course we are lucky that in India prisons are still run by the state. We have,
Exactly.
so we are very lucky in that sense. You say the prison is not a solution. Of course, you said 69% of the non-violent crimes do not call for imprisonment, physical imprisonment. What is the alternate? See, there is an offense, there should be punishment. I'm sure you are not against the offense and the punishment as such. Primarily, you want the punishment to be in a different forum rather than physically being imprisoned.
Well, it's interesting that you use the word punishment. You see, for me, I don't think punishment is a very helpful concept when it comes to crime, because it takes away the focus for me from what the criminal justice system is for. The criminal justice system, in my opinion, should be to reduce crime, so that you have a lower level of crime in your society. That means that you have fewer victims of crime, that you have less property and other losses and financial losses from crime. And that's really, I think, what the criminal justice system is for. And the problem with using punishment as your objective, as the goal, is that that's the way in which the US model is focused. That's why they have such long sentences. That's why they have the death penalty in many states in the US. And there are young men in America who are going to jail at the age of 21 or 22 for life without parole. So in other words, they'll never be released for drug crimes. Now, that means they may be in prison for 60 or 70 years for selling an ounce of marijuana or cannabis or hashish or whatever you choose to call it. Now, that's punishment, okay? But what does that do? It sucks a huge amount of money, that's millions of dollars to keep that person locked up. It's millions of dollars in lost taxes. They're never going to pay taxes. They're never going to work. And it's millions of kind of dollars in terms of the overall law enforcement, the policing, and all the other budgets. Now, what I am looking at when it comes to why do I say that you should use prison less and you should use alternatives, is because the alternatives in every country that has lower levels of imprisonment and uses non-criminal ways of trying to deal with non-violent crimes, they all have a much better success rate at reducing the amount of crime and the number of victims. And I give a number of examples in the book. One of the most sort of famous ones, and I deal with it in a little detail in the book, is in Norway, where they send very few people to prison. And when they do, the prison environment is much more like the real world. They live in accommodation blocks where they cook their own food. It's more like small apartments or sort of shared living of the kind that you would get in any country in the world. So when they come out of that environment, they have training, they have skills, they have a job, they have still maintained contact with their family and their children, and they come out and they go back into a job and they carry on and they become a part of normal society. And they only have a 20% reoffending rate of people coming out of prison. Whereas in the UK, and that's after 2 years, In the UK, we have 40% after 1 year and 75% overall. So 3/4 of those who go to an English prison will commit another crime. That means another victim. It means more harm, more damage. So I'm not arguing to be soft on criminals. I'm not arguing that to make their life easier. I'm saying let's make our lives easier. Let's make the tax-paying citizens' lives easier. Make sure they have fewer crimes committed against them, that they're less likely to have their children attacked in the streets or their houses burgled or be robbed at knife point. And that's the reason. And that's, as you know, in the book, I propose some radical solutions around, I say that if you need to detain people, we live in an age now which has facial recognition. We have it on our phones, which has retina scanning, excuse me, which has fingerprint scanning. You can detain people in their own home. You can let them go to work so that they would scan in, scan out. They could have GPS tracking on their phone. And you can still monitor people just as effectively, but without the cost of keeping them in prison, which is huge for the state. In England, we spend £50,000 a year on each prisoner on average, which I'm not sure what that is in rupees, but it's what, 65,000 US dollars. So it's a lot of money every single year. And so we spend all of that money, and when they come out, they go and commit more crimes. So I'm saying let's spend a little bit of that money on surveillance and fingerprints and all the other stuff, and let's monitor when they go to work. If necessary, their parole officer or their probation officer, as we would call them here, they can have a FaceTime every day. Where are you? What's happening? They can use the technology in a way that now we just put them in prison. And I give an example of a young man who went into prison at 21. And within weeks, he was a heroin addict. He'd never tried heroin before. And he was a criminal for the next 20 years, just because he was sent to prison for a few months. And that's what prison does to people. It makes them more criminal, make them commit more crimes. And that's why we need to stop doing it. Rip it up, knock the prisons down, and start again.
So you mean to suggest that their liberty has to be curtailed in the same way as if, except barring that their physical imprisonment is taken away. They are free to move in the society. They are earning their livelihood, so also taking care of their families. So the repeat offenders are avoided.
Exactly. And the evidence is crystal clear. Wherever you look in the world, that there is a direct link between high levels of imprisonment, long prison sentences, and high levels of violent crime. And that's the link. And where you go the other way, where you use lower levels of imprisonment, where you use much more rehabilitation and education as part of your criminal justice system, levels of crime are very low. So anyone that wants to reduce crime needs to read my book and follow what I'm suggesting, and within 2 or 3 years, you will see a dramatic reduction, and particularly the worst kinds of crime that people are most frightened of, which is violence on the streets, from drug crime and from robbers and people who assault them. That's what people are really afraid of. People don't want to get harmed. They don't want their children to be attacked. They don't want their houses to be burgled or broken into. That's the sort of crime that is massively greater in our system, where we use prison, where we criminalize drugs, where we criminalize children. I mean, in England, I don't know about in India, I must admit I didn't look it up, but in England we send children into the criminal courts from the age of 10. I mean, 10-year-old children in a criminal court. Now, 10-year-old children can't vote, they can't drive a car, they can't really do anything legally. And yet somehow we are saying in England, at least, they can still be a criminal, and we can still send them to a court and treat them like an adult for the purpose of crime. If you treat a 10-year-old or 11-year-old or a 12-year-old child like a criminal, what will happen is he or she will be a criminal forever. Because once they're in the criminal justice system, they don't come out. And as I point out in the book, a vast number of the young people in our prison system started off in the youth justice system. And they were criminalized as children. We said, you're a bad person, you're a bad child, you're a criminal. And what do? When you tell a child that, they behave like that. Children learn from the way that you treat them. And so, we need to do radically different things all over the world. We just don't have the money. If you think about it now, we as a society, as a world society, are just probably spending trillions of dollars on relief for COVID, on trying to prop up keep jobs going and everything else. Trillions. We don't have hundreds and hundreds of billions to waste on failed criminal justice policy. So my book is a manifesto, not just for reform of criminal justice, but how can we save billions, hundreds of billions of dollars and make the world a better place? Well, it's a no-lose. It's a no-lose situation.
And reduce the crime. That's the motto that
And reduce crime, reduce the cost of crime, reduce the misery, the human misery of crime, and make our world a happier and better and safer place. And that's all I'm interested in. I'm not interested in, as I say, I don't want to make excuses for criminals. That, you know, that's not my job. I do that as my day job, but that's not why I wrote this book. I wrote this book to say, do these things, you will have less crime and a happier world. And who doesn't want a happier world, Rajendra?
Well, to put it in a nutshell, you mean to say that prison system, the alteration should be, instead of physically locking up, I found, wait for your argument. While I was doing some research, surprisingly and interestingly, I found wait for your argument in the United Nations Convention on Transnational Organized Crime and the protocol thereof, wherein the serious crime is defined. In the serious crime, in the definition of serious crime itself, they do not say, the word imprisonment itself is not used. They only say deprivation of liberty. The term used is deprivation of liberty.
Exactly. And deprivation of liberty comes in many forms.
Yes.
And I made a television series here in the UK for the BBC, which is available on BBC iPlayer. I'm not sure if it's available in India at the moment. It might be on BBC India. I'm not sure. But I made a television series, and we went and filmed. The series was called Crime, Are We Tough Enough? And it's certainly available still on the iPlayer here in the UK. I know many in India have the ability to watch English television by one means or another, of course, sometimes by VPNs or what, I don't know how it works, but I'm not encouraging it. But I know people do. But the point is that in the series, we went and filmed at a technology exhibition, which had all of the latest technology for monitoring people electronically, using artificial intelligence to monitor people's movements and, as I say, facial recognition, all the rest of it. You can deprive people of liberty anywhere, indoor, outdoor, anywhere you like. You can do it electronically. Now, of course, you wouldn't do that for someone who was a very dangerous murderer, who was likely to go and stab someone in the face. But for people who have not committed violent crime, and you just need to make sure that you know where they are and what they're doing, the technology is so much cheaper than prison, and it's actually so much more effective at stopping them reoffending. So at the moment, we lock them up for a while, we let them out, they go and commit more crime straight away. If you don't lock them up, you go through a process where they can continue to work, or they can get a job, or they can go into training and education. But you say the most important thing of all, actually, Rajendra, is many people in prison lose touch with their families completely. They lose their family network. They lose touch with their children, so their children are not looked after properly. Their children are more likely to become criminals because they don't have a father figure in their life, or a mother in some cases. So anything that keeps family units and keeps people in contact with their family and keeps them working and paying the rent or paying for food, that's what gives people a stake in society. That's why you get up in the morning, Rajendra, so that you can look after your family. If you had no one to look after and no one looking after you, you didn't care as much, and you're much more likely to drift into drugs. You're much more likely, not you personally, but you're much more likely to become a criminal of some sort. And so we just need to keep people invested in society and part of society. The more we do that, the less likely they go back to crime in the future.
Well, very well said. Now, another interesting point, or rather, which of course, you make the whole world question itself, the very legal system. I would, when I read some of the chapters, it was taking like a matter beyond the psychology of a human. Now you call the narcotic drugs have to be legalized. And I'm sure that is one of the arguments that you're making in your book. How do you support that narcotic drugs? In my understanding, narcotic drugs has a serious effect on the very societal structure. The young children, or even the older people, get addicted, and once they are addicted into the narcotics, of course, it's unlike an alcohol or other smoking, etc. This narcotics drugs has a very serious effect of addiction. Once they are addicted to it, the crime rates go up for whatever reasons. So younger children tend more to get addicted. Of course, in all of the world, and in many of the developing countries, that's a serious problem for the states to tackle with. Now you advocate legalizing drugs. how do you justify
Well,
that?
first of all, I'm not sure if I heard you correctly, but I think you said unlike alcohol and tobacco. Of course, it's exactly like alcohol and tobacco. They're the most deadly substances that people take. Tobacco in particular is the most deadly killer of people, of something they take voluntarily. And it's also nicotine is the most addictive drug there is. So you're absolutely, you're absolutely right to draw attention to alcohol and tobacco, but they are heavily addictive substances, and substances that kill hundreds of millions, or probably certainly millions of people a year all over the world. So yes, we do have those substances. They are legal in most countries, including most of India. I know that you have parts of India where alcohol is not legal, for example. I know there are some states which don't allow alcohol, although I'm sure you can get it in those places, as you can anywhere, let's be honest, somehow. But the point is, you by drawing attention to those things, you sort of prove the point, because the other thing you said was that drugs, people become addicted to them and they cause a lot of harm, and they then go out and commit crime or do other bad things. That's with drugs criminalized, and that's why they do those things, because drugs are criminalized. If you remember the US experiment with prohibition of alcohol in the early part of the 20th century, the consequence of prohibition of alcohol in the US was that you ended up with a huge organized crime problem, vast amounts of violence from those who were supplying the illegal alcohol trade during prohibition. And what then happened is the US realized that was a mistake. So they repealed the Volstead Act, which brought in prohibition, and they went back to a licensed, legalized and regulated system for alcohol. And that's what I'm advocating for drugs. I'm not suggesting that drugs be legalized so that anybody can sell them anywhere to anyone. That would be crazy. And we don't allow that with alcohol. You have to have a license in the UK to buy alcohol. You have to own it to adults. There are certain premises and places that you can sell alcohol, and other places where you can't. And so I would just introduce a similar system of regulation and licensing for drugs. And when you talk about the harm of drug, one of the chapters of the book, there's a whole chapter about why we should legalize drugs, and the arguments definitely apply in India. I mean, I've seen the problems of drugs in India. I know how many addicts you have, particularly in your large cities, and the problems caused by alcohol, just as we have by drugs and alcohol, actually. But just as we have in our cities here in England and every other major city everywhere in the world has a problem with drug addiction. But when I went to Switzerland, I spent some time in one of their heroin-assisted treatment programs, where the Swiss government and it was a referendum of the Swiss people, so the people voted directly to introduce heroin-assisted treatment for heroin addicts. And what that means is that in Switzerland, if you're addicted to heroin, you can go twice a day to a clinic. You will be given health checks. You will be given HIV testing or hepatitis testing. You will have, all of your health needs will be considered. But twice a day, you're given pharmaceutical grade heroin. Pure heroin, not mixed with rat poison or something else that drug dealers crush up into their drugs to make more money. So, and the experience in Sweden is that those heroin users in Sweden commit virtually no crime, because they don't need to, because their drugs are provided by the clinic. They are in far better health than heroin users in India or in England, and they are almost, none of them will die from overdose, because they know exactly what they're taking. It's in a bottle, it comes in a syringe, the exact quantity is measured out by a nurse. So unlike someone in India or in England who's down a back street taking a powder off of a dealer and mixing up on a dirty spoon and dirty needle and putting it into their arm, and there's no hygiene. In Switzerland, they take their drugs in completely hygienic circumstances, and many of those in the Swiss drug treatment program are going to work every day and doing a job. Now, heroin users in England, and I imagine it's the same for serious drug addicts in India, hardly any of them do a day's work ever, because all they do is go around trying to commit crime to get money for drugs. In Switzerland, they don't. So, one of the things that the most important learning that I came across during my travels was, the more you legalize and license and regulate drugs, and they've done it to a degree in Portugal, in Europe, and they've done it with heroin in Switzerland and various other places, again, it's the same point. Much less crime, much less violence, a smaller number of people dying of overdose and dying of serious health conditions. So do we want our drug policy to reduce those crime and death and destruction and misery? Or do we want to just punish people because we say that it's immoral and bad? Well, if we want to just punish people because we think it's immoral and bad, we're doing it the right way, but the consequences as a society, we're paying a heavy price for that, and many people are dying for it. I'll just give you one statistic. When the Misuse of Drugs Act came in England in 1971, which was the legislation which still exists now, the act which basically prohibits nearly all drugs and has heavy penalties for drug dealing and drug supply and even drug possession. Before that act came in 1971, in the late 60s, there were only about 1,500 English people who would have been classed as heroin addicts. And they got their heroin from doctors who gave them a prescription, and they got a pharmaceutical grade heroin, and there were a small number of them. And they were largely white middle-class people who, for whatever reason, had developed this addiction. But it was a tiny, tiny number of people. Within a decade, so by the early 1980s, after prohibition from the 1971 Act, we had 350,000 heroin addicts. So, just think about that. They were street addicts. They were getting their heroin from dealers. We created this enormous organized crime structure around the supply of heroin, and then crack cocaine, and then obviously powder cocaine as well. All of these very, very damaging drugs had suddenly been handed over to criminals who wanted to sell as much of it to as many people as possible, like all drug dealers do everywhere in the world. Before that, we had the licensed, regulated system, prescription through doctors, very small numbers of drug users. Post-prohibition in the UK and in the US, because the US drugs legislation came in at exactly the same time, introduced by Richard Nixon in 1970-71, exactly the same, war on drugs, let's have a war on drugs. And they've been fighting that war, and the only person they're fighting against is their own people by killing them. So it's insanity. And I explain in the book, I go back 200 million years ago to when there is evidence from the record of archaeological finds and so on of human beings, and they were obviously not modern humans, but prehistoric humans were taking psychoactive substances 200 million years ago. The cannabis plant evolved 28 million years ago on the plains of central and northern China. And people have been taking it, smoking it. It's been used as a funeral rite in China for tens of thousands of years. People in India have taken drugs of one kind or another since history began. And it was a religious ritual. And then suddenly again, India bought into this. Just the Americans just forced other countries to go down this war on drugs line, and all we've done is make the problem worse. So let's license it, regulate it, and let's treat it as a health issue rather than something to punish people. And by punishing people, punish the whole of society by making drugs one of the biggest causes of crime. And the biggest, we just need to stop doing that. And the book makes the case, I hope, in a really powerful way why we need to do that.
So in other words, if I rightly understand, you suggest the war on words is not prohibition. The war on words can be by regulating it.
It has to be regulated. You can't just legalize it and let anybody do whatever they like, because you don't do that with alcohol, or at least we don't in England. You're not allowed to brew whiskey and sell it from a shop. You have to have a license to produce it. You have to put a label on it with a health warning. There's all of these rules around tobacco and alcohol supply. You need to have the same model of regulation and licensing. And for me, I don't think I would allow private corporations into the market. I wouldn't allow it to be a for-profit model. Obviously, we have alcohol as a profit model and tobacco as a profit model. I think that's wrong. I think if we started from where we are today, I don't think we would allow private corporations into alcohol or tobacco either. Possibly alcohol, but because it's a slightly different argument. But tobacco, which has no purpose other than feeding the addiction to nicotine, doesn't have any other purpose. I don't think we would allow private corporations into that market. And if we hadn't, I'm not sure we would have had smoking as the way people took nicotine. People are largely now turning to nicotine through vapes and through other things where they're not, because it's the smoking, which is particularly unhealthy. But no, I think licensed government dispensaries where the drug supply chain is controlled by the state, the dosage is clear on the box or the packet, people sign to say they understand the health risks. That's the way to do it, not just let dealers run free on the streets. I'm not advocating that at all.
it should be licensed and regulated. And uh, one of the short stories that I could gather from your book is that you have written, of course, in fact, I felt so sad uh, coming to know of that case of that 15-year child who took
Martha.
91% of heroin, something. Can you please elaborate it for the benefit of
Yeah.
audience, because that will have a serious impact in the minds of the governments as well.
I hope so. So you're very right to bring that case up. So I interviewed many people for the book, and one of them was a lady called Anne Marie, and she had a daughter called Martha. And Martha, at the age of 15, with some of her friends, went out one Saturday and they got hold of some MDMA powder, which is ecstasy. People might know it as ecstasy. I don't know what you would call it in India, but MDMA, it's a slightly hallucinogenic drug that people take in clubs to get high, basically. And anyway, Martha and her friends decided to get some of this MDMA powder, and she took some of it, and they got it from a drug dealer locally where they lived. She took some of it, and within a few hours, she was dead. And the reason she was dead was because the powder was 91% pure MDMA, and it was so strong, and there was so much of it, that it would have killed a horse. It was enough for 10 grown men. And she was a very slight and slim young 15-year-old girl. So she took that powder and collapsed and died in hospital just a few hours later. And I interviewed her mother for the book. And her mother is now a campaigner for drug regulation and drug licensing, because she believes, and I agree with her, that Martha would still be alive if she had known what she was taking, because she wouldn't have taken it. If she had a bottle or a tablet that told you that this is 7.5 milligrams or it's 6%, and this is the amount you need to, just as with alcohol, it says on the size of the bottle, it's 5% alcohol of a beer or whatever it is. Children would not go and drink an entire bottle of 100% neat spirits, a litre down in one, because that's impossible. A, you can't really buy it, and B, it would just, you wouldn't even be able to get to the end of the drink, you'd be sick. But with a tablet that size or a tiny bit of powder, you can take enough to kill you in an instant. And so the argument that Martha's mother, Anne Marie, made, and I tell the whole tragic story in the book of Martha's death and Anne Marie's campaign. But the arguments that we both make, and that Anne Marie as a mother who's lost her only child, she only had one daughter and she'll never have another one. So she became, as she said, a mother of one, and then became a mother of none in just a few hours. And the argument that she makes is that, children will do these things, sadly. 15-year-olds in England are going to sometimes experiment with drugs. We should try and educate our children not to do that, but they are going to do it sometimes. And if they're going to do it, they should be able to know what they're taking and make sure that they're not going to be surprised and killed because what they put in their mouth, they had no idea what it was. So sometimes, as I say, drugs are full of rat poison or just all sorts of horrible things which make the person very ill or even kill them. Or often it's another thing, which is they're just too strong. Because drug dealers don't have a pharmaceutical factory to mix the drugs to the exact percentage and the correct number of milligrams per tablet. So you might get one that's 91% pure and the other one's got nothing in it because it's mixed up in a cement mixer or in a home blender in someone's kitchen. And that's how drugs are made. And it's insane to me that you allow those sorts of drugs out into society that are made like that. But in England, at least, we have all sorts of rules and regulations about how to make a chair or how to make a children's toy. There are heavy regulations for safety reasons for every product in my house, but children can go and buy drugs that don't even have a label saying what's in it. And that's, to me, is madness. We need to have the same approach to health and safety and to keeping children safe as we do with other things that are potentially dangerous. The alcohol on the shelves that I have here in my house, there is no risk that I'm going to drink something and I don't know what it is. I know exactly what's in the bottle. I know exactly how much alcohol is in it. I can measure it out. With drugs, nobody can do that now. And that's why it's so dangerous.
Well, I hope the people in the helm of affairs take your advice, or rather your views, very seriously to tackle this drug issue, which is prevalent, and of course, which is now very, very rampant. Rather, it was not there so much in India, but now also it's too much. I have been hearing about this drug menace. I hope your book It's, as you said, it's not only for lawyers, it's also for all kinds of people who are able to think for the benefit of society.
It's a book of ideas, and it's a book I hope that's just entertaining and people will find interesting. And particularly in India, you'll find a side of English justice which you will find quite, you know, unless you've been to and seen the English criminal court, you know, people will find it's a very different world. There are a lot, but also at the same time, you will read it and think, you know what, this murder case was in Manchester, let's say in England, but it's just like a case I dealt with in Mumbai. You know, people, it's amazing. The similarities. There are more similarities between you and I, Rajendra, in our respective jobs and our lives, even though we come from thousands of miles apart. We're in very different cultures, but we have a lot more in common than we have that separates us. And I really hope lots of people in India will read the book and find it really interesting.
Of course, we have similar, we also have juvenile justice systems, wherein, of course, I know that you have dealt heavily on the children, the delicate way in which children who are in conflict with laws have to be dealt with. Can you just elaborate? Now you said the children in UK as young as 10-year kids are treated as adults for offences.
They are for criminal process. So in the book I explain about how lots of different countries approach children. And the example I give is probably my you know, the argument that I make is around Luxembourg. So Luxembourg, obviously a very, very small country, but Luxembourg doesn't have child criminals at all. So the age of criminal responsibility in Luxembourg is 18. So it's the same age at which you are allowed to vote. So the way in which they look at it is the two things really go together. You have the rights of a citizen at the age of 18 to vote, but you also then have all of the responsibilities of a citizen at the age of 18, which means that you have to be responsible for your actions under the criminal law. Up until that point in Luxembourg, and I believe it should be the same everywhere, up until that point, if you commit an act which would be a crime, I don't know, maybe even a murder, or some other form where you steal something and you're a 10-year-old or an 11-year-old, that should be treated as an issue for education and the welfare of the child, not to punish them and to set them up to fail. Because if you take a 10 or 11 or 12-year-old and you, instead of saying we're going to put you in a criminal court, the judge is going to shout at you and tell you you've been very bad, you may even get locked up in a young offenders prison. If you do those things, you will make that child a criminal for life. But if you say we're going to put you in a school which can help you if you have problems, we can work with you, you'll save a lot of money because education is a lot cheaper than prison for children as well as adults. But also you will mean that those children are much less likely, as is the case in Luxembourg and several other countries. Spain is another example, much bigger country than Luxembourg. But you will find that the children actually end up growing up and becoming part of society in a normal way and don't become adult criminals. So that's why, again, I'm not saying, you know, be soft on people just for the sake of being soft. I'm saying that I don't believe that young children are sufficiently mature and developed to be fully responsible, as adults are, for crimes they commit. And if they are not old enough because they're not developed enough, then it is deeply unfair to treat them like adults when they are not adults. There are all sorts of things, as I say, we don't let children do, where there are age of consent in relation to sexual things. There are all sorts of minimum ages before children are allowed to do things or things can be done to them. But when it comes to crime in England, we say, well, you're just the same as an adult. And they're not the same as an adult. Yeah, I don't know if you have children, Rajendra. I have 4 of my own. They're not adults. They are children. They think differently. They behave differently. They have many years of development before they will be fully responsible. And we need to develop them and nurture them, not punish them like as if they're adult criminals.
Well, thank you. And of course, the constraint of time I have got. I'm looking at the time we have got. We are privileged to have your appointment for limited time, but I have promised I have promised the young lawyers, so also the law students who are pursuing law, that you will give, highlight on the UK legal system. So also the ways in which the young graduates can practice law. You can just
Of course. So a couple of things on that. First of all, those who may or may not have seen that I have a YouTube channel, which is Crystal QC. You can Google that on YouTube or search on YouTube, and you'll find during lockdown here in England, which went on for about 3 months or so, I made a series of videos aimed at young people and law students and young lawyers. There's 12 of them altogether. They're only short, 5-6 minutes each, giving tips on things like your application, on how to deal with an interview, on how to prepare yourself, how to approach your education, different kinds of practice, how to get into criminal law, various other kinds of tips, if you like. So if they want to look at things in a little more detail, they can find that on the YouTube channel and you know, get some use out of that and just watch that whenever they have time. But answering your question, so I came from a very ordinary background here in England. I didn't have rich parents or rich family. My dad was a builder. You know, I worked with him on building sites growing up. So I didn't have a kind of like a barrister. I didn't know any barristers. I didn't have friends. My parents' friends were not barristers or lawyers or doctors and such like. So I kind of, I guess the tips are these, that, you know, lots of people in India do have those advantages. I know there's obviously a very large middle class population, lots of children who do have professional parents, so you can give them lots of support. But equally, there are lots of people in England, in India as they are in England, who don't have that, and who basically, you know, their only route to get out of a situation that may not involve lots of money or professional successes in their family, their only route, let's be honest, is education. And education is the absolute key to everything. If people want to become a lawyer, we all know that becoming a lawyer, just as becoming a doctor or another professional, you must have a good education. So that means every stage of your career, every stage of your educational life, work hard. Work hard at your exams, do your training, you know, do your languages, because I know that speaking English is very important for legal practice in India. The English language is still used in quite a lot of the more higher courts and so on. So, you know, make sure you work on your English language skills, but work across really hard in your education and get out there as well and get some experiences. You know, people who think they want to be lawyers, young people, go to court, link up with lawyers who are already there, ask for advice, ask for mentoring. As I say, go along to court, try and get some experience, volunteer, say, I'll spend 2 or 3 days in your office, I'll do your photocopying, I'll make your tea, I'll do whatever, just to get some experience and make some connections and make some contacts. But most of all, work really, really hard in your education, get, you know, focus and aim and plan for where you want to get to, and work really hard at every single stage. For me, the most important ingredient for success in law, and it's the same in pretty much anything, is that you just have to work very, very hard. If you, and don't expect anybody else to give you anything, because if they do, you're very lucky, that's a bonus. But everything I've got, the things that are worth having in my career, and I've had a very successful career for a long time, and it's brought me, you know, a lot of happiness and also a lot of material rewards, you know, and also the opportunity to write books and things like that, which only come from success. People wouldn't be interested in my book if I wasn't a QC, if I hadn't achieved the successes I have. So how did most of that happen? It happened because I worked really, really hard and did the best that I could at everything in front of me. And when I worked hard and did a case well, the client was happy and he told someone else. And that person came to me and I worked hard on his case. He told 2 more people. So all of it comes down to being the best you can be every day, working super hard. You know, if you send out a CV for an application, make sure it has no spelling mistakes. I can't believe how often, I'm sure it's the same for you, how often you get a CV and there's spelling mistakes, or even they spell the name of the firm wrong that they're applying for. Things like that, just small details matter. So be a perfectionist, work really hard, you will succeed.
Yeah, rightly said. I also believe in the same philosophy that hard work alone matters in our profession, more especially. I also have come from the same way from the state school, from a state school, and I have worked up, of course, still a long, long way to go despite 22 years into this profession. And thanks, Chris. Anyway, I'm very thankful to you for having devoted your time for such a wonderful webinar. And I wish today is your book's release in India. I wish all the very best and success for the book. So also, I hope and wish that this book benefits the world community, the civilized community at large. Uh, Before I part, I'm reading some questions from the audience. If you permit me, I'll take the questions.
Of course.
Yeah.
Oh, on the Q&A.
Yeah, Q&A. This question is asked by uh, uh, our partner, my dear friend of mine, Sukamrinder Singh Ahluwalia is a very good lawyer from Delhi, my partner. India being a common law country shares similar procedure for trial adopted in England, beautifully written by Sir Stephen. As per the doctrine of presumption, the accused can be arrested considering circumstantial evidence. So in the cases of extradition, where accused is charged under money laundering, can't Court of England take strict view about it?
Yeah, I understand the question, and the court does take a strict view, but the court needs to see the chain of evidence between the money. Let's say that the Indian suspect has $1 million in a bank account in London, just for example, and the Indian government says this $1 million comes from fraud. And therefore that's money laundering. That's the proceeds of crime, and he has transferred that, and that's money laundering. The English court will need to see the mechanics of how the fraud is proved. So how do you prove it's fraud and not legitimate income, for example, or dividends or some other form of completely legitimate wealth? And how do you prove knowledge? How do you prove that there was criminal intent? So the court will take a strict view, but it will also scrutinize the application strictly. So it will look at whether that chain of evidence has been established, at least at a prima facie level. And that's the test. So the Indian government doesn't have to prove the case beyond reasonable doubt or to the criminal standard, but there has to be a prima facie case on the paperwork. And that's often the problem, because suspicion isn't enough. So many of these cases, sadly, have come before the court for extradition at a stage when there is suspicion but no proof. And that's the problem. We don't allow extradition to category 2 countries on the basis of suspicion alone. There has to be a prima facie case, just as there would be for a case to go to trial in England. A judge can say that you haven't got a prima facie case, the case can't go to trial. Well, it's the same test when it comes to extradition. Is there a prima facie case of money laundering? So it's not enough to say that this particular very wealthy Indian man has lots of money. Lots of Indian people have lots of money. It's proving that that money comes from fraud is the problem. So it's a good question, and it's true that there is that scrutiny and it's a strict approach, but there's also a very, very clear evidence-based and logical approach.
I'll take one more question. I'm seeing in the Q&A box. Again, question from Sukamrinder Ahluwalia from Delhi, wonderful lawyer. In Amsterdam, certain amount of drugs are legal to carry. What's your say on that? Amsterdam.
That's true, and it's the same in Portugal. And in fact, in Portugal, there's a certain amount of any drug is legal to carry, not just marijuana, as is the case in Holland, in Amsterdam. The problem with that limited approach is that, yes, it does have some positive effect in that you don't get small-time users of drugs being criminalized and locked up, but they're getting their drugs from criminals. And that, for me, is the problem. That as long as you allow criminals to operate as the suppliers, the main supply chain, then all of the problems of gang activity and violence still carry on, and they still have those in Holland. They still have gangsters supplying most of the drugs. They do have some licensed coffee shops which supply cannabis, particularly to the local population, but most drugs in Holland and most drugs in Portugal are supplied by organized crime gangs, and they kill each other if they fall out, and they use children to move drugs from one place to another. And that's something that would never happen in a licensed and regulated system.
Oh, wonderful. Thanks a lot. And that's all is the question. Thank you very much. And it was a pleasure and privilege for me to, interact with you for more than an hour. And thanks a lot for all the time that you have dedicated. And I wish you all the good luck for the book. The next day I'm going to have this book on my table. I cannot wait for the book.
Good. Well, I hope others will order it, and I hope if you enjoy it, you'll leave a review on the Amazon Indian website. It would be good because I'd like, as I said to you yesterday, I'd quite like to sell to 10% of the Indian population. I'd be quite happy with that. It'd be very good.
I hope your wish comes true, because we have festivals tomorrow and day after. I wish your wish comes true with the.
Well, I wish you well for your festivals. So no work tomorrow?
Tomorrow is a restricted holiday. Day after tomorrow is Ganesha festival, which is very, very popular in India.
Ah, one of my favorites. I was there last year for that festival in India.
Oh.
And it's wonderful. I love to see all of the flowers and all the people celebrating, and it was nice to have days off and lots of nice food on the streets.
Yeah, certainly. And Ganesha is very, very, celebrated throughout the country, more especially in Mumbai. It's a huge festival.
That's where I was in Mumbai last summer. I was there for this festival, and beautiful city. Lots of rain though this time of year. Yeah. Doesn't stop raining for long.
Yes. So let's hope we get rid of this COVID by the grace of God. And as soon as.
Thank you so much, Ajendra. I very much enjoyed it, and thank you for all of the people who have been watching. I've seen on the screen, so I hope you've enjoyed it too, and I would love to be in India with you soon, and perhaps we'll do another event next year.
Thanks a lot.
Take care. Have a great evening.
Bye. Bye.